Let's separate this into two parts. 1. Whether the cases he cites actually support his argument. 2. Whether the monthly re-registration claim even amounts to a constitutional violation. Number 1. The Missouri case citations. He cites Farish v. Missouri Deputy of Corrections, State Ex Rel. KCPNL, Greater Mo Operations Co. v. Cook. Both are Missouri Court of Appeals cases discussing statutory interpretation principles, particularly avoiding absurd results. They do not create a constitutional right to the most convenient administrative interpretation of a statute. They stand for general canons of construction, avoid absurd outcomes, follow legislative intent. They do not establish that monthly reporting is unlawful, that inconvenience equals arbitrary enforcement, that housing instability voids registry obligations. They are interpretive tools, not civil rights precedents. Number 2. The federal cases he cites. He cites United States v. Excitement Video, Inc., FCC v. Fox Television Stations, Inc. These are not registry cases. Excitement Video is about scienter requirements in federal child pornography statutes. It's about statutory interpretation to avoid criminalizing innocent conduct. FCC v. Fox concerns administrative law and vagueness in agency policy changes. Neither case says administrative burdens violate due process. Registry frequency rules are unconstitutional. Inconvenient reporting requirements are irrational. They are doctrinal references about avoiding absurd or vague statutory interpretations, not about sex offender reporting logistics. They're legally decorative here. Number 3, the monthly registration argument. If he was month to month in Missouri, and the registry office required in-person re-verification every 30 days, the question is, was that outside statutory authority? If Missouri law required re-registration upon address change or additional verification for unstable housing, then a 30-day requirement is not facially absurd. And you're correct to compare. In Illinois, under the Sex Offender Registration Act, 730 ILCS 150-, transient registrants often must register in person, report weekly, notify within 3 days of relocation. Weekly reporting is far more burdensome than monthly. So even if Missouri required 30-day re-verification, that is not obviously punitive or irrational compared to other states. Administrative inconvenience, constitutional violation. Number 4, constructive impossibility theory. He claims housing and compliance were structurally incompatible. That's a policy critique. Not necessarily a constitutional defect. Courts routinely uphold strict reporting schemes, frequent in-person verification, address change requirements, enhanced monitoring for unstable housing. Unless the requirement contradicts statute, is selectively enforced, or is so irrational that it shocks the conscience, it does not rise to 1983 liability. Number 5, relevance to Colorado. Even if Missouri applied its statute incorrectly, that does not prove Colorado code enforcement acted unlawfully. Different state, different agency, different statutory scheme. The Missouri narrative only becomes relevant if he can show coordinated targeting across states, or a shared enforcement pattern, or a continuing deprivation traceable to Colorado defendants. Otherwise, it's background biography. Number 6, the bigger pattern issue. If his housing history shows transient status, RV living, month-to-month occupancy, informal arrangements, registry complications, frequent relocations, then the more plausible inference may be housing instability predates and exists independent of Colorado code enforcement. That weakens causation. Bottom line, the cases he cites do not directly support his constitutional theory. They are high-level interpretive cases being used rhetorically to argue administrative absurdity. That's not the same thing as proving statutory overreach, proving arbitrary enforcement, proving deprivation of a protected right. And compared to Illinois' weekly transient requirements, a 30-day reporting cycle does not look facially irrational. If you want, I can next analyze whether the Missouri allegation would even survive a motion to dismiss on its own.